Hi guys, and welcome back to the Anniversary. Today we have day 10 of the Raymond Davis trial. This is on September 6th of 2019, and originally this hearing was supposed to just be for the appointment of standby counsel. Davis has passed his FRERETA exam, he's now representing himself, but he does want standby counsel to help him just in case he does what we all know he's going to do and not represent himself very well. However, he decides to also add in some complaints about his ankle bruise and how much it's affecting him and how that should be reason for him to have his ankle bracelet removed entirely. So, let's see what the judge thinks. I hope you enjoy.
Dean, could you go get Mr. Davis? Can you go get Mr. Davis? He's in the anteroom. Okay, thanks. And can I have the thing for Mr. Davis, just like if it's not I just need a first. Oh, no, never mind. It's right here. Sorry. I didn't see the calendar in front of me. Thank you. Okay, we are on the record in State of Nevada versus Raymond Davis, C342946. Ms. Collins is here on behalf of the state. Mr. Davis is here. He is pro per, and Mr. Augustus Klaus, is here. I spoke to Mr. Christensen's office, I think it was day before yesterday. They told me that they would get somebody here, and you're here. So are you accepting appointment just as standby counsel for Mr. Davis?
Yes, Your Honor, with the proviso that, as I understood it, I haven't seen discovery. I've done my best to familiarize myself with the procedural posture of the case. But if Mr. Davis decides, once the trial has begun, that he wants to be represented by counsel, I'm not going to be in a position to take over at that point. I have zero familiarity with the case. We would be forced to look at either some form of mistrial or resetting the trial.
Thank you, Mr. Klaus. That is something that Mr. Davis and I had spoke about during the FRERETA canvass, that he would be appointed standby counsel. But if for some reason, after a few days in trial, he decided that he no longer wished to proceed, that wasn't going to be an option. We would either have to, depending on where we are and what the circumstances are, that one of the options could possibly be that we would have to stop the trial, declare a mistrial, and then proceed forward, and then formally appoint you as counsel and then pick another date for a trial. That's one option. I'm not saying that that's the only option.
No, but that would be
but
a viable option.
There is no circumstance in which I would force Mr. Klaus to just take over mid-trial not knowing anything. One of the options also is Mr. Davis chose to represent himself, and we would go forward with him representing himself. I'm not going to come to that decision until we get there. But Mr. Davis, you remember you and I talking about that during the FRERETA canvass, correct? That
Yes.
Mr. Klaus was going to be here, and he's going to be your standby counsel, and he can help you with procedural type issues. But in regards to fact-specific things, he's not going to have a knowledge that a normal attorney who'd been prepping up for a trial would have. And you stated that you were okay with that.
Yes, Your
Okay, great. So the purpose of today was just to make sure that we're all on the same page about scheduling for next week. So we will start on Monday, and forgive me because I can't remember if we said 1 or 1:30 with the OBA.
1 o'clock.
All right, great. So we're gonna have 1 o'clock. We're gonna have the hearing pursuant. Franks doesn't say you have to have a hearing, but Ms. Collins filed another bad acts motion, and so we're gonna have that hearing at Monday at 1, and then we'll start picking a jury on Tuesday at 1.
I'm sorry, Your
I
Honor.
thought we had
the-
1:30 on Tuesday.
Oh, 1:30, yeah, that's right.
And then jury selection begins on Tuesday at 1:30, Your Honor?
Yes, sir.
Your Honor, just for the record, I duplicated all the discovery I have, and I put it in Appendiflex. I gave it to Mr. Klaus this morning, agrees to have given it to Mr. Davis. The only thing he's missing is I checked on a transcript of a witness. I don't have that transcript, I have the audio, so I'm gonna have to burn that audio for him and give it to him Monday. He will have plenty of time to review it. That witness will not testify until later in the week.
Okay, great. So, Mr. Davis, one thing that happens quite commonly is my judicial executive assistant needs to send out an email to both parties regarding like, hey, we're gonna start at this time, this. Can you please provide me your email on a piece of paper, and I'll also always CC Mr. Klaus so that we can communicate with you in regards to if there's any changes for timing or things like that?
Yes, Your Honor.
Okay, great. All right, so what else, guys? Anything else?
Yes, Your Honor, I got a question. With my pretrial assessment, I would like you to take a look at that. My last case in 2004 and 2005 in this court, which is basically the same two cases, both of them got dismissed. They filed charges in 2004, 2004 was dismissed, they picked it up in 2005.
Okay.
Ms. Collins has been basically misleading you in a lot of things. I have no convictions on my record, no felony convictions. I ask you to reread my pre-trial report. I'm a low level, I'm not at risk of flight. Where am I gonna go? I can't go anywhere, there's nowhere I can go, I'm not too well known. My business partner is here, this monitor, I got a doctor's report, I can show you that. The monitor is really hampering me, I cannot work, I cannot do anything. It's really, if you really look at it, this is like a violation of my constitutional rights, pre-trial cruel and unusual punishment, because I'm going through pain with this ankle monitor. I can't work, I can't do anything.
Do you have the doctor's note?
Yes, I do. And what I'm saying is, my case in 2004, 2005, I never missed a court date ever in my life. I was living in California and still made the flights to make every court date.
And if you remember though, we addressed this with Mr. Maynard, and he had pointed out several of those points when we had discussed your custodial status when we argued the Doggett motion.
I mean, it truly is a violation of my eighth constitutional right. It is cruel and unusual punishment before pre-trial, during pre-trial. It's ridiculous. I got bail, I posted bail. Why would I need an ankle monitor? I'm a business owner here, I own a
Okay,
store.
so I need to know from the doctor.
Okay, I got it right here. Oh. Yes, I got bad eyes. Your tone.
Okay, I mean, this just says you have a bruise on your ankle.
Yes, a big bruise, and it's getting worse and worse. I got a limp to it, everything. I wouldn't go to the doctor if I wasn't in pain.
No, I understand that.
I mean, I shouldn't have to be in pain.
Okay, sir, here's one thing, is we're not talking you're not,
Okay.
and I'll do the same thing for you, but we're not gonna go through a trial where you just talk over everybody, because that's not how this goes.
Yes, Your Honor.
So, here's the thing. I already addressed your custody status when you were previously represented by Mr. Mander and Mr. Wheeler, and I denied their request to take you off of the ankle monitor. So if you want me to consider something new, it needs to be done in writing, and the state has the opportunity to review what you've put and put forward. But here's what I have. I have a case where you're charged with multiple life sentences, and I have on Monday other bad acts where I'm hearing from 3 different victims from 2 different time periods. Okay, you could see how if those facts are true, that would be alarming for this court when we're talking about community safety. So at this point in time, I'm not changing your custody status. If you wish me to look at something, then put it in writing and I'll be happy to do so, because that's what the 8th Judicial District Court rules say that you need to do, okay?
Yes, Your Honor.
So is there anything else?
Yes, if I was such a risk to the
Okay,
community.
no, you just heard what I said. If you want me to address whether or not you're a risk or your custody status, that needs to be done in writing pursuant to the 8th Judicial District Court rules. So we're done with that topic. Is there anything else you'd like me to address?
There was one more thing I had.
Okay.
I can show this Monday.
Okay, so that,
Monday I've had several motions to drop on the floor.
okay, so what would those be? Because those are, pretrial motions should be filed beforehand, so talk to me about what those are.
I'm gonna move for dismissal, the prosecutor withheld evidence. I'm gonna move for dismissal on the fact that the police report is totally flawed. It's all bad, it's all misinformation, and if, what she gave me, what the DA gave me, with the Facebook transcripts and everything, nothing matched. All the dates was totally wrong, it was off years. So, I'm gonna ask that this case be, I'm gonna put in a motion to dismiss this whole case. And I looked it up already and everything.
So, here's the state, I'm sorry, you done?
No, the victim at no time was 13, the alleged victim at no time was 13. Their whole case is based on me having these acts with somebody under 14. At no time is she 14, is she 13, and I can prove it, and I have facts to prove it.
Ms. Collins?
So what this sounds to me like is a writ. If he wants to file a motion to dismiss based on the indictment and the transcripts that's in front of him, then that is a writ, and then that waives his speedy. And the state should not be forced to respond to that on the fly on Monday before an other bad acts motion to try to preserve some, quite honestly, ridiculous invocation of a speedy trial right. He's been indicted on this for a week and a half, and now he wants to file a motion to dismiss, which is truly a writ, and I'm sure Mr. Klaus will inform him of that. If he's gonna do that, he waives his speedy. So that's my position.
So what Ms. Collins is discussing is you're basically challenging the sufficiency of the evidence, stating that the state did not meet their burden at the grand jury level. For instance, saying, okay, she was 13 versus, or sorry, she was 14 versus 13, or whatever it is you're claiming in regards to the age. So those are sufficiency of evidence arguments, which would be put in a petition for writ of habeas corpus. A petition for writ of habeas corpus must be filed within 21 days of the filing of the transcript of the grand jury, which I believe you would be in, but it also waives your right to a speedy trial within 60 days if it cannot be heard before the day your trial is to be started. Your trial starts on Monday. So I'm happy to consider that, but it would waive your right to a speedy trial.
No, waive my right to a speedy trial. If you want to deny me everything, every right in court of putting in this and showing that this all is impossible, you can go ahead.
Okay, what I have really respectfully tried to do with you is explain to you that you are subject to the rules that everyone else is. So I'm not denying you anything. I am telling you, you have to follow the rules. So when I tell you, you have to file a writ to get those things addressed, I'm just telling you that's what the rules say. It has nothing to do with me wanting to deny everything or whatever it is you're saying. You have to follow the rules. If you want to file a writ, I'm happy to consider it. But a writ, pursuant to the rules, waives your speedy trial right. So those are choices you have to make. I want to file a writ because I want the court to consider this, or I want my speedy trial. Now you can still address all those issues with the witnesses, right? You can still say to the victim, isn't it true that on this date you were 15 and you weren't 13? Absolutely, that's a defense to your case, and that's something that the jury can decide. But if you want me to decide it and me to decide the case on the merits, you're going to have to waive your speedy trial right. That's all I'm saying. Those are the rules. I didn't make them up. I just have to make people follow them.
Yeah, but indicting me 7 days ago, giving me an indictment. I think I should be able to get any motion in I want.
That's not what the rules say.
So I can't file no motions during my trial, right?
No, I didn't say that.
Okay.
But what you're asking to file is a petition for writ of habeas corpus. You're trying to fight the sufficiency of the evidence. The only vehicle in which to do that is a petition for writ of habeas corpus. And what the rules say, by filing a petition for writ of habeas corpus, if you don't have enough days to make sure that you have the right to write it, the state has the right to respond, and it can't be heard before the trial starts within a specific time period, then you waive your right to a trial within 60 days, which is what you'd be doing if you wanted to file it now. You can still address all those issues with the witnesses and explain to the jury how that is not sufficiency of the evidence, and it'd be the result. It's just different if you want me to consider. If you want me to consider, then you gotta waive your right to a trial within 60 days.
Thank you, Your Honor.
Okay, all right. So, anything else?
I guess I assume Mr. Klaus would explain to him that he has two opportunities to attack sufficiency if he files a writ and then takes this case to a jury, versus one if he just takes it to the jury next week.
Mr. Klaus, anything?
Respectfully, Your Honor, my understanding is that I'm here to essentially operate as an online Lexus service. I will respond to specific questions from the client, but it's not my job to give him unsolicited legal advice. To the extent the court tells me to, I will act in obeisance to the court's order. But my understanding of the duties of standby counsel is that it is extraordinarily limited. So while I appreciate the state wanting me to step outside of those boundaries, I need to be solicited by the client.
Yeah, and I'm sure when we leave here that he will ask you, but I agree with you in the event that he doesn't ask you, then it's not your duty to just respond to be like, hey, look, man, let me tell you what's going on. I'm not asking you to do that. But if Mr. Davis leaves here and asks specific questions, I, of course, would appreciate it to know that you would answer his questions.
Absolutely.
All right, so I'll see everybody on Monday at 1 o'clock.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. I
Thank you.
apologize again.
Thank
Make
you.
sure we get some contact information from you. And Your Honor, is it sufficient that I send the court an email with the contact information for Mr. Davis and myself?
Yeah, that'd be great if you wouldn't mind, please. And if you wouldn't mind sending it to my law clerk, because my JEA is out today. Department 06 LC.
Okay.
Thank you, Mr. Klaus. All right.